today's public hearing of the Vetting Commission established under Law Number 65 of the year 2023 on the external evaluation of judges and candidates for judges of the Supreme Court of Justice. I'm Scott Bales, the chair of Panel B of the Commission, and I declare today's session open. This hearing is being conducted under Law Number 252 of the year 2023 on the external evaluation of judges and prosecutors and amending some normative acts. It's also being conducted under the Commission's Rules of Organization and Functioning. The subject of today's hearing is Vitalie Budeci, the judge of the Chișinău Court. On the 17th of June, 2024, Judge Budeci was appointed via temporary transfer to the Central Court of Appeal. Judge Budeci, welcome.
Da, bine v-am găsit, bună ziua.
I'm joined by two other panel members at the hearing room, Mr. William Brower and Mr. Yuri Gatskin. The panel is also assisted by members of its secretariat. Also present in the room are members of the public and the media. Photographer will be taking pictures just at the outset of the hearing. The hearing will be conducted with interpretation between Romanian and English. To allow for accurate interpretation, I ask that everyone speak clearly and slowly. Furthermore, the proceedings are being recorded. The recordings of the public hearings generally will be available online on the Commission's website, www.vettingmd.eu, within 3 days after the hearing. If the hearing is closed in part, that will not be available on the Commission's website, but that portion of the hearing will be recorded for the materials of the evaluation file. During the hearing, one or more of the panel members will pose questions to you. Please answer them truthfully and completely. Your explanations are important to the panel in verifying your financial and ethical integrity. At the end of the hearing, you will be given an opportunity to make a brief closing statement. In posing questions, we will take into account your privacy and, where required and possible, the privacy of your family members and close persons. We will omit unnecessary details, including such things as ID numbers, bank account numbers, specific real estate addresses, and so on. For the protection of privacy, we ask you to do the same. Judge Budeci, we note that we received your email on the 4th of August, 2025, in which you questioned the need to discuss in a public hearing some issues mentioned in the hearing notice. As I noted, we will state our questions in a way to avoid unnecessary intrusions on privacy. If during the course of the hearing you believe there is a reason to close part of the hearing, you may make that request and the Commission will consider it. Do you understand that process?
Da, și vă mulțumesc.
Yes, understood, and thank you.
Okay. I will begin by briefly reviewing the evaluation process for Judge Budeci. The Commission initiated its evaluation on the 13th of January, 2025, by notifying the judge by email and asking him to complete and return an ethics questionnaire and the declarations required by Law Number 252. Judge Budeci returned the completed declarations and questionnaire on the 23rd of January. As part of evaluating a subject's ethical and financial integrity, the Commission also obtains information from many other sources, such as the National Integrity Authority, the State Fiscal Service, the General Inspector of the Police, other public institutions, financial institutions, and open sources. The Commission assesses the information it obtains for relevance and reliability. From March through May 2025, the panel asked Judge Budeci 3 rounds of questions to clarify certain matters. During the first and third rounds of questions, he requested extensions to respond, which were granted by the Commission. They provided answers and documents within the time limits. On the 25th of July, 2025, we notified Judge Budeci that the panel had identified some areas of doubt about its compliance with the ethical and financial criteria and invited him to attend today's hearing. On the 28th of July, 2025, he requested access to the evaluation materials, which the commission granted. On the 4th of August, Judge Budeci submitted written comments regarding the preliminary findings identified in the hearing notice. Judge Budeci, before we proceed further, do you wish to make any corrections or additions to the answers that you've previously provided to the commission?
Domnul președinte, stimați membri comisiei,
Chairman
nu
and
am
esteemed members of the panel, I have no other additions to make except what I've already provided. That still stands.
Thank you. Are the answers that you provided to the ethics question and declarations that you returned on January 23rd, 2025, are they still accurate today?
Da,
Yes, that is correct. I confirm.
Okay. Members of the panel will now ask you some follow-up questions. We will try to keep our answers short and to the point. We ask that your answers be short and to the point as well. Panel member Willem Brouwer will start questions.
Thank you, Mr. President. Ms. Budeci, as you have noticed in the hearing notice, there are 3 items that we are going to discuss. And most of it you have clarified in your reaction to the hearing notice, but there are 1 or 2 things that I would like to clarify, to clarify over here. It's about the donations from relatives, your mother-in-law, your father-in-law, your father, and it's about non-declarations of cash savings and these donations. And there is a 3rd item, which is more juridic item. It's a certain case you have handled. To start with, you have stated that you had some donations from your mother-in-law who was living and working in Italy, and these donations were not declared in your annual declaration. To be clear, your wife made an annual declaration in 2013. I believe she was then working at customs. Is that correct?
In 2013, my wife, I think, yes, she's already started to work in the customs or in the mayor's office. Now I can't remember precisely.
But at least it was clear that in that year you had to make this declaration. You were not obliged to do so, but this declaration was for your family. In 2014, your wife was on maternity leave, is that correct?
My wife, on the 12th of July 2014, has delivered the second child, and that's when her maternity leave started.
Thank you. And in 2015, you became a judge, and therefore were obliged to file these annual declarations. Is that correct?
Yes.
Thank you. You said, you argued that you and your wife didn't declare the donations received in 2013 and 2015 for 3 main reasons. You stated that there was a lack of clear methodology. What exactly do you mean by that?
Thank you for the question. When I stated that there was no clear methodology, what I meant was that once the law on the filing of declarations was passed in 2012, At that time, there weren't very clear guidelines as to what had to be reported in these declarations, as I've also mentioned in my response to you. Also, well, the declarations were being filled out, we were told, for the general public, for the people at large, the public at large, to know what the income of the family is, considering their salary, their earnings, or our earnings from the work that we do. But now, moving a little bit further along the line, we didn't think that well, the support we were provided by the mother-in-law from Italy, we did not regard that as donation. That was like some help for us, some support for our family to actually be able to survive. We were somewhat, I should say, perhaps hesitant about how to actually regard these amounts that would be transferred to us with particular periodicity.
Well, 2013, the first year, and then 2015, when you became judge. 2014, you didn't declare, of course. But what I don't understand is you are a lawyer, you are a judge, you are educated in law, and you say there was no clear methodology. What was unclear?
Well, to us, we did not perceive it an obligation to report amounts that weren't that significant in the declarations of assets. We didn't perceive them as such. As previously stated, we've had some hesitation about it. We were not certain, which is why I've stated that I accept the criticism about this conduct. But those amounts were not large amounts of money that could have somehow enable us to have a luxurious lifestyle. It was just like we've seen it as some financial aid or financial support to us, not as a donation.
In your reaction to the hearing notice, you mentioned this similarly. What you wrote was, we didn't perceive the financial help received from the in-laws as donations. For me, it's still not clear. Somebody gives something to you and you don't perceive it as donation. How do you see a donation then?
Look, in our view, a donation that is something like a gift that is significant, or a significant amount of money from outside of the family, from somewhere outside of the family. So to us, those amounts we were receiving, we just regarded them just like any other present, so to speak, would not necessarily be reported, such as if somebody gave my son as a present a bicycle, so we wouldn't necessarily report that. So that's how we thought about it. To us, a donation would have been something that would have come from outside the family.
Okay. You stay with further explanations. Thank you for that. Then there is another reason that you mentioned. And the same reason you mentioned when asked why did you declare it, that's and I have to read this, you were afraid by declaring this income that the family would come under the attention of criminal elements. And what do you mean by that? Just to explain this.
I have provided this explanation specifically with regards to that period of time when I was already working as a judge. In this period of time that is covered by the notice, 2017, 2018, 2019, There were quite complicated cases that I was examining. There were quite high-profile cases that I was working on. And at that time, I was really feeling, in certain situations, I was feeling somewhat threatened. Not necessarily that I would have been, that I was threatened that I would be subject to some physical attacks. It wasn't necessarily that, but the circumstances, the situation was quite, what should I call it, not favorable, given the work that I was doing, because the cases I was examining were really important, high-profile cases. Ultimately, there have been cases when certain judges, somebody broke into their houses, the houses of judges, and had stolen amounts of money from them. So what we didn't regard as big amounts, I mean, what we had at home, so I was thinking that it wouldn't necessarily be good to let it be known publicly, to just keep ourselves safe. Yet, there was a reason, but not the main one. The main one was the one that I have already explained, that I've mentioned. And second of all, I think that what matters is also the reason that, especially after 2016, 17, 18, when the law on declarations encompassed that exception in Article 4, Para 3. So, given that, I was thinking that those amounts that are not beyond, do not exceed the 10 average salaries in the national economy, well, I thought that didn't have to be reported, because it felt like it was in line with that exception. But then I've seen in the third round of questions as well, in the notice that was shared with me, I realized what the position of the Commission was in terms of how this could be interpreted, or how the NIA interpreted it. However, I believed that those amounts fall within the framework of that exception, and that the amounts at issue didn't have to be reported. If you noticed, I've mentioned that fear when I was filling out the answers to round 2 or 3, I think, as I was writing the answers to one of those rounds, when I was asked why in 2023 and 2024, why did you declare certain amounts that do not fall within, or, well, that are not beyond the 10 average salaries in the national economy. And my answer was that, having seen that, and having been aware of the fact that this procedure of vetting has been launched, so with awareness of that, I realized, and then I decided, our family decided, and in fact, we were also provided some advice by some friends. They recommended us, just to avoid any doubts whatsoever, to start report, just declare everything we had. So, at that point in that declaration that was filed in 2025 and in 2024 for the 2024 declaration already, we have reported all of the amounts of money that we had, even though those amounts were smaller, I mean, under the threshold of 10 average salaries in the national economy, which was in Article 4, Paragraph 3.
It seemed that during that later period you had some kind of an instruction from NIA on these declarations.
Yes, There have been clearer instructions developed, and then we've also had some meetings in the court as well with the representatives of the NIA, Financial Integrity Authority, and they have explained to us in greater detail what has to be reported and how we need to fill out the declarations. And it became clearer to us. We were somewhat reproached, or maybe that's not the best word. We were told that, look, in 2024, 2025, you declared absolutely everything. So we decided to do it like that in order to avoid anyone having or raising any issue with our family. Let's best report everything we have because there's nothing for us to hide.
Thank you. Just this is curiosity because you are a judge, and every now and then you encounter a law that is not very clear, or which methodology could be clearer. What do you normally do to find out how it should be?
Well, normally, we read the law attentively. We look into the practice of courts, how particular cases are being handled, with a focus on the uncertainties that we are confronted with in solving certain cases. And we also seek advice from more experienced colleagues where that is required. And I'd like to say that out of discussions with a number of people, again, speaking of the past, such as 2018, 19, so even after discussions with people who either worked at the NIA point or were working at the NIA, we would say, so the amounts that are under 10 average salaries, are they to be reported or not? Or are they exception for Article 4, Paragraph 3, whatever is the question with them? And they would tell us that the exception applies to everything. So I believe that maybe not even the NIA had that much clarity about this matter. They might have lacked clarity as well. And these interpretations started to come around once the evaluation process was launched. This is my explanation. Unfortunately, I can't find another way to put it.
Some time ago, of course. Still, this exemption of Article 4, Sylvia talked about it. It's about 50,000 lei, I think. It's about gifts. And you're right, the law doesn't say gifts in kind, but it has to be interpreted as gifts in kind. But if it weren't, let me put it this way. If it also would be about money, you could receive 100 gifts of 50,000 lei without having to declare, which is, of course, not the spirit of the law as such. But at least you didn't interpret the law like that then, nor did the people that you talked with. There is a discrepancy between judges, what we see in the vetting process. Some of them, as from the start, declared everything they had, and some didn't. So, about this declaration, it's my colleague. Questions? Yes.
Just a little clarification, if I may. So when we're speaking about that exception provided for in Article 4, Paragraph 3 of the law on the declaration of assets, that's not about 15,000 lei, that's 10 average salaries in the national. So there's been an exemption from declaration, so that has been an exemption applying to those gifts that are not that significant, that are not of a big importance. So I was under the impression that we had fallen in line, and at least that's how we have interpreted that exception. And as mentioned in round 3 and in the response to the notice, we had understood the situation, and to address such situations, now the law was amended and that exception is gone, perhaps specifically in order to address any misinterpretations and to make sure there is utmost transparency. But I think that the spirit of the law was not to overload the declarations with all sorts of assets that are minimal and don't have such a big value. But the spirit of the law...
Slowly for the translation.
Okay.
Yes, you can go on. Right.
So, in my opinion, the spirit of the law was for any public official to report in the declarations the assets of a significant value, not only in possession, but also as a beneficiary of such assets, or any asset that would, with the purpose of making sure that there is transparency with regards to the assets and what belongs to that person for the people to know. But it was not the purpose to focus on the small, insignificant presents or things. I think the spirit of the law requires public officials to declare their wealth in order to prevent some acts of corruption and in order to make sure there is clarity for everyone, and not to just have any asset declared that is not of a significant value. That is my opinion. Thank you.
Thank you. Before I come to my colleagues, one other question. In your written submissions to the Commission, as a reaction to the hearing notice, you said usually that you would only formally indicate a wealth declaration, the income received from your job and the real estate ownership. Do you remember that you wrote this down?
Domnul Braur, eu nu mi-amintesc dacă am indicat formal.
I can't remember whether I've stated formally. Perhaps if that's what it says, if that's what is written, if that's what I've written, then perhaps that is the case.
Explain what I mean. In your, let's say, first row of declarations, you only indicated your income from your job and the ownership of real estate and nothing else. And as I understood, but you will certainly explain it, you meant that this was this declaration obligation was experienced as a pure formality. Is that correct?
Well, the actual declaration of wealth, that is a formality in itself, meaning that it's an official act. You file this declaration, an official document. In my view and my wife's view, when we started reporting, declaring our wealth, we thought it was important for the society to know what salaries we had, what real estate we have, what loans we've taken out. We didn't think it was that important to show every little remittance, every little few hundreds euros from the mother-in-law in Italy.
Thank you. Go to my colleagues. On this item of the annual declarations, are there any questions from your side?
Good afternoon. Now, Mr. Budeci, as you've noted in the notice of hearing, the Commission focused on 2013 to 2018, on that period, with a focus on the donations from your mother-in-law. 2, 4, 6,000 euros, in total about 23,000 euros in this time span. Could you tell us now, these funds, were they meant for your family alone, or were those funds meant for other people as well? When I was particularly speaking of the help, of this financial help from my mother-in-law to us, I have declared what was meant for our family, not for other people. Until 2015, when the father-in-law had passed away, he worked in agriculture and it was quite prosperous. He was a farmer. And what I've declared, reported with regards to those amounts, yes, that was meant for us.
From what you know, did your mother-in-law provide support to her other children, for the other sons or daughter? I anticipated such a question, and actually it makes sense. You may have noticed that I mostly mentioned monthly support from the mother-in-law until 2015. So that's a period before I became a judge, because the salary, my wife's and my income from the activity that I had were quite small. And at that time, my wife's brother had an own activity, from what I know, and he received some help from the mother-in-law previously. And over those years, my mother-in-law helped us. And when I became a judge and started to have a salary that was more or less better, we almost gave up on that monthly help. We actually told her that we try to handle our daily life based on our own resources, and that's why the help almost stopped, except for the support we received later from like sale of land that I declared when changed the apartment and we started repair works. That was a support that she deemed necessary to offer us, because the resources we had were not enough in order to complete all repair works. But going back to that support provided to us, yes, at that time she was mostly helping us, because my wife's younger sister was still living at home, and my father-in-law was supporting her. We were a young family at that time who needed support. We have just had our second child back then, and at other times she possibly helped her other children too. Between 2019 and 2024, you declared only one donation, major one, 25,000 euros. Besides the data mentioned in your asset declaration, were there any other donations, like the monthly ones that you are mentioning, that were not included here? No. Speaking of monthly help, no. We are getting around on our own. So that financial support was until 2015, as you were saying. Yes, as I mentioned. Thank you.
Mr. Bills, do you have any questions? Oh. We go on a little about your mother-in-law, and as our chairman already said, you wrote an email to us stating that you would like to avoid personal things from this public hearing. I suggest that if you think what I ask is from a very personal matter, then you say so, okay? Okay.
Okay.
Because I have first no questions about her marriage, but about her ability to support you, and especially in 2013, 14, 15, 17, and 18. You claim to have received from your mother-in-law 6,000 euros in monthly portions, but she had a gross income of 11,669. Considered that she also must have had costs, how on earth was she able to pay you these 6,000 euros? Can you explain that?
Yes, of course. I did that in the answers, in the written answers to those questions. I will try to speak in a way in order not to reveal too much of her personal life. But I mentioned, first of all, that my mother-in-law has been in Italy since 1998 or 1999. I also told the Commission that I will not make reference to income obtained by her, let's say it in a way, without proper documentation, because until 2008, I mentioned that she stayed in Italy without being documented, and she could not get an official salary, obviously. But I mentioned her social contributions, the official income that my mother-in-law started to get in 2008. As I mentioned, she has never rented an apartment there. She always stayed with the families that I listed, the people that I mentioned. And she almost had no expenses to incur, because you take care of a family, and if you cook, that's where you also eat, and you live with that family. So she had all the necessary conditions for living and eating. My mother-in-law's main purpose in leaving for Italy was to ensure a good living for her children and grandchildren. She did not go there to buy cars, apartments, houses, and other goods. She went there to help us. For a period of time, she helped her son. Another period, she helped her daughter. Well, maybe, possibly she helped her son. I did not ask, and it's not okay to ask it, but I declared to the Commission what applied to our family. At least, if we do some calculations, 6,000 out of 11,000, I believe that it's okay for a mother to help her children from the income that she obtained. At least I did not declare help or support that would be bigger than the income that she received.
Okay, thank you for this answer. I just go on following those years, 2014, the same question. You claim to have received 6,000 euros from your mother-in-law. Her annual income in that year was 9,124. You also said that your mother-in-law transferred through the bank 2,800 euros in 2014. This would add up to 8,800. That compared with a gross income of 9,124 is slightly out of balance, I would say, but perhaps you can explain how she did it.
First of all, I mentioned in 2014 a total support from my mother-in-law of almost 6,000 euros, and I said that some part of the money were coming through like packages sent, but I did not remember, was it wire transfer or not? Unfortunately, I did not keep any documents. These figures that I reported are approximate. That's from what I remember, that year, approximately, there were some amounts like that. And I did not say that it was 6,000 plus 2,800. It was all in all around 6,000, because she did not send more than that. It was about the way she sent the money that could have varied. Partially it was sent with these packages, partially transferred.
I think I understand what you mean. You say the total.
If I may.
Moment. You say the total that she spent on you was 6,000, and this included the 2,800. Do I understand you correctly?
Yes.
Please go on.
I forgot to mention one matter. In my answer to round 2, question 1, I provided, on the letter D, I provided a small calculation, and I mentioned that support coming from my mother-in-law was not necessarily coming from the money she received that specific year, because she had some savings, because she had an official salary starting in 2008 and forward. It doesn't mean that all the money that she earned a month she was sharing away. She also had savings. And one more thing that I wanted to mention. I will reveal some parts of personal life, but not too detailed. As I said, she was not only living off of her income. She was in a relationship with that person, a family-like relationship, and what she earned, she was mostly sending us to her children. That's the answer.
You don't need to go into details on that right now, perhaps later, but you'll see that. Well, in fact, I can ask the same questions about 2015, 2017, and 2018. But am I correct that you will give the same answers as you gave for the previous 2 years?
Yes, I don't have another explanation.
Okay. I go to my colleagues. Do you have any questions about donations from the mother-in-law? Mr. Chairman, Mr. Bales?
None for me.
Thank you. Then we go to the donations of your father-in-law. Your father-in-law, if I understood correctly, had passed away in 2015. And he had a vineyard, or what kind of agriculture company did he have?
My father-in-law passed away in April 2015, indeed. Before he passed away, he was in full capacity. He worked until his death, because his death was very sudden. He owned a peasant farm, registered as a peasant farm, and he owned several hectares of vineyard. So it was land where he was growing grapes. Besides that, he had other farming land plots where he was cultivating cereals. That's the answer to your question?
Yes, that more or less answers the question. You say, in your response to the hearing notice, you say the following, that if the Commission would not accept the donations from the mother-in-law, the Commission should least accept the donations from the father-in-law. Could you explain why you state this?
Because I got the impression that the Commission, in a very persistent way, tries to deny the support received from the mother-in-law because they have no official documentary confirmation. In case of bank transfers, the Commission accepted the amounts, but when I declared constantly that I was getting monthly support with these packages that were sent, I got such an impression that the Commission is very apprehensive about that kind of help received from abroad. That's the feeling that I got. That there is no documentary proof of that help. Well, you know, I am not sure that it's normal in a family to have documentary proof of support provided by parents to children. I was just thinking that as long as I mentioned the amounts, and you saw the amounts that the father-in-law did not provide to us, they were not very large. I was thinking, since that money was not coming from abroad, the doubt about that money shouldn't be there.
Okay, thank you. You made it clear. Then, is there any question about donations from the father-in-law, Mr. Bills? No, thank you. Then there is donations from your father. In your communication with the Commission, you've indicated that you received 2 donations from your father in 2019. You claim that you received a donation of €4,000 to furnish your apartment and 6,000 that was given directly to the workers working to repair your apartment. Do you have anything to add to this statement?
No, that's what I stated, and I support that.
You also claim that this €4,000 that was given to you for furnishing were not spent in 2019, but it was saved to be used later in 2021-22. How, I mean, you have a new apartment, you have rebuilt it, but it should be furnished. Didn't you have any furnishing in your apartment? I can hardly imagine it, but how did you live then?
As I declared to the Commission in all 3 rounds of questions and later on to the hearing notice, I will try to gradually and chronologically explain the things. We started repair works based on the money that we had. We were aware that for full repairs, a much bigger amount is needed. We did some partial repairs in order to be able to start living in that apartment. And, by the way, I reported the amount that I had available and the amount that the mother-in-law offered to us in 2018. Later, there was a period when the works stopped because we did not have resources, and that is particularly the year 2019. We were living in a partially repaired apartment, and as I told the Commission, we brought some furniture from our parents that they did not need anymore, because we did not want to buy something cheap and something that would wear very quickly. We wanted to save some more money or contract a credit and after we finish the repairs, would furnish the apartment at an acceptable quality. Therefore, the money. So, since there were no repair works, almost no repair works in 2019, yes, after my father sold his apartment, and I think I mentioned that quite clearly the reasons why he sold it. The fact that he offered us that support, thanks to that help, the works continued. And later on in 2020, we took a loan because I did not know how much a bank would offer us. And we did not want to spend immediately the money that my father gave us, because we did not know exactly what sizes of furniture we needed. That's why we waited. And he gave us the money, and I mentioned the purpose for which he gave us the money, but money wasn't spent right away. We waited out to see how much we could get from the bank, and later on we could work within the available funds.
Thank you. One thing that puzzled me was the 6,000 euros that your father-in-law paid directly to the constructor, and you didn't declare it because it was given directly to the workers and not to you. Do you still hold this stance that that would be the correct way to deal with it?
In the answers provided to the Commission previously, and in the reply to the hearing notice, and today, I'd like to mention that I don't believe this is the right approach.
Okay.
Yes, I am aware now. Now I realize, and as I mentioned for the Commission, after things became clear about declarations and everything that has to be reported, even things that don't need to be declared, I will keep declaring them, because this is a better way to avoid any suspicion and any interpretation. But I accepted that this wasn't the right approach on my side.
Okay. Thank you. Any questions? Mr. Bills, any questions? No. Then we have the cash savings. Well, you have given a lot of answers to the cash questions, cash savings. In 2016, you have indicated cash savings of 150,000 lei and 7,000 euros. This adds up to 302,517 lei. And in 2017, you have declared 100,000 lei and 7,300 lei, which amount to 2,000, sorry for the translation, I'll say it again, 252,570 lei. Among other reasons, you mentioned that you didn't declare these sums to NIA because you were afraid for the safety of your family. You explained that. And you explained that in 2018 and 2019 you underwent a training by NIA, and you learned that these kinds of sums should be declared regardless of any fears. Do you have anything to add on this matter? You already said a lot about this.
No, it's what I mentioned already.
Okay, thank you then. Well, there is 2014 a bank transfer of 2,500 euro from your mother-in-law, but that is documented. The only thing is that money was transferred to you for medical aid for your wife, but you explained that you didn't spend it on medical aid, but saved it. Can you tell me on what, eventually, on what item did you spend this money later?
Eu nu știu cum se
I don't
procedează.
know how it is done in other families, but our savings are not structured by source of origin. In 2014, as I explained, the purpose for which my mother-in-law transferred the money was mentioned. Yes, she transferred that for my wife to have money in case she needs it. I already mentioned we recourse to services we did, and we decided not to waste that money as long as we could obtain medical care in a state institution, state facility. And the money was saved in our family for other needs, and subsequently, as I reported when I spoke about savings went lower or higher depending on the amounts that we had available. So yes, somehow this money was merged with other amounts of money. I can't state right now that out of this amount we spent money specifically for this purpose or another.
Okay, thank you. In the hearing notice, you have seen that during the years 2023, 2018, 2019, your expenses were higher than your income. You have written some responses on the hearing notice, and I would like to check whether I understood those responses well. There is a sum of 80,000 lei, and there is a sum of 300,000 lei spent on the repairing of your apartment in 2018. This sum of 80,000 lei, is that included in the 300,000?
Da, eu atunci când...
Yes, when I talked about that amount, I also in the written rounds, I provided explanation that at the beginning, when we started the repairs, we had 220,000 lei, give or take. And together with the 80,000 lei that I said, what we received as support from the mother-in-law, altogether it added up to 300,000.
Just to clarify this, and in 2019, the same question, or more or less the same question, was the sum of 118,020 lei, or in other words, 6,000 euros, was it spent on your apartment in 2019?
Este acea sumă despre...
This is the amount that I mentioned that my father paid directly to the workers.
This was a 6,000. Okay.
Da.
Okay, thank you. Questions on this subject? Chairman? Questions on this subject? No. Then I come to my last object. It will be very short. You were involved in a case, detention on remand case, on a suspect named Masayev. And this case has been brought to the, excuse me, This case had been brought to the European Court of Human Rights, and the European Court of Human Rights decided that this detention on remand of almost 60 days of Mr. Masayev was not just, it was arbitrary. You gave an extensive answer to this problem in your answer to the hearing notice, and you may add whatever you like, but I have got one question. You were the first judge to decide, investigating judge to decide over the first period of detention on remand. Is that correct?
Yes, that's true.
To her here. This detention on remand was prolonged, was extended. Did you extend this detention?
No.
No. I applied detention on remand only at the initial stage, only the first time. Its extension was done by another judge.
Okay, thank you. We have read, of course, your answers and also your reaction to the hearing notice. Do you stay with this explanation you gave on how to decide on a first instance detention on remand? Or do you have anything to add to that?
No, I tried to be as clear as I was capable of in my explanations to the Commission, and there's nothing for me to add outside of what I've already explained.
Thank you very much. Colleagues, any questions? Mr. Bales? No questions? Then I'm finished. I give the word back to the chairman.
Judge Budeci, before we conclude the hearing, would you like to make any statements? Is there anything you'd like to say?
I would like to say that this process, well, first of all, I would like to thank the members of the Commission and to thank the entire team that worked on this task. It is something that is very complex, I believe, and it is an exercise, an activity that has, I think, kept us on our toes, not only me, but my entire family and close people to me. We have learned about some things that were maybe quite novel for our society. Well, there's a lot that I understood out of this, and one of them is that everything you do, you need to keep some records of that and to store that information and to keep very strict, clear records. And unfortunately, I didn't do that for certain and in certain periods of time. I would like to ask the Commission to at least try to comprehend the specificity of our society, to try to understand that the negative balance that was referred to in the notice of hearing, that is not money that one could say it came from some illegal activity, or well, I mean, that can be easily covered if the explanations that I provided are taken into consideration. The help that I talked about, provided by the closest of people, my parents and the parents of my wife. I would like to believe that the Commission will apply the same standards as it did previously in relation to help provided like this. And I hope it will take into account that the substance matters over form. And the fact that we don't have pieces of evidence or supporting documentation per se with regards to the handover of some help, support from parents, I don't think that that is grounds to not take such help into account for the inflow calculations. That support was provided, and I believe that I've managed to prove that the parents had the capacity to provide such help in that period of time. And I would like to address one more thing, because it's that period around 2013 that was subject to this evaluation, and unfortunately my parents in that period of time, 2013 to 2015, my parents, they didn't really have the possibility to help us out. My mother has become very ill and she required someone to take care of her, and she needed some money for the required healthcare to be provided to her, to my mother, and those who are watching us, I wouldn't want them to believe, though, that we were only provided help from the parents-in-law, but from all parents, my parents as well. But until my mother has become ill a longer time ago, they've all helped us equally. That's what it was like, and it's regrettable, the fact that those amounts, the amounts that I had received during the reporting, during the evaluation period, I did not regard them in the same way that is expected now, or I did not regard them the way they are being regarded now. And I told the Commission, but I would like to reiterate that I accept this criticism about this matter, and there's been some hesitation and there was no ill intent behind it. And I hope that this will not impact our entire family. Thank you.
Judge Budeci, thank you. We've come to the end of today's hearing. We appreciate your submissions and answers to the Commission's questions. After the hearing, the panel will approve an evaluation report stating its conclusion whether the subject meets the criteria for ethical and financial integrity under Law Number 252. The panel will strive to complete and approve its evaluation report and announce its conclusion as soon as possible. Today's hearing is now closed. Good day to everyone.